You're all set whenever you're ready.
Good morning, everyone. I'm Andy Clyburn, Assistant Town Manager, and I will be holding this morning's hearing, which is the second virtual public hearing on the proposed amendments to the Town Manager Regulations, Part 4 of the Code of the Town of Barnstable to adopt grant of location regulations. It is Wednesday, the 12th of July, 2023, just past the hour of 10 o'clock. With that, I'm going to turn it over to Town Attorney Karen Over.
Thank you, Assistant Town Manager Clyburn. Good morning, Karen Nover, Town Attorney. As Assistant Manager Clyburn said, this is the town's second public hearing on its proposed grant of location regulations. These are town manager regulations which address procedures and standards for the placement of wireless communication facilities in the public rights of way. I'm going to quickly review the process to date and where we expect to go from here. On June 30th, 2022, so a year ago, the town posted an initial draft of the regulations on the town website. Comments were received, revisions were made, and a revised draft of the regulations was posted on March 1st, 2023. A public hearing was held on March 23rd, and the town manager left the hearing open for 30 days to allow additional time for comment. The town received written and oral comments, and those comments were reviewed by the town manager, the town attorney's office, the planning and development department, and the town's outside counsel. Additional revisions were made to the proposed regulations, and on May 30th, a memo summarizing the comments received and the town's response was posted to the town website along with a redline version of the revised regulations. We anticipate that today's hearing will be the final public hearing on the proposed regulations. The town will review and consider any comments it receives through the close of business on July 28th, when the comment period will close. The town manager will make any additional revisions he deems appropriate, and a final version of the regulations will be posted on the town website as soon as practicable after July 28th. The town has been working closely with its outside counsel, Attorney Alan Mandel, who is an expert in telecommunications law, to develop these regulations. And I'm now going to turn this over to Attorney Mandel, who will give a brief summary of many of the changes, not all, but many of the changes that were made to the regulations after the March hearing and comment period. Attorney Mandel.
Thank you, Karen. The materials that were posted by the town include a redline version of the proposed regulations, which show changes made since the prior draft. Also, the town manager distributed a memo which goes over various comments from different stakeholders, CTIA, residents, ART, and provided some responsive comments on that. What I'm going to do is cover a few of the changes, but the changes are all reflected in the materials that were made available. First is the notice of hearing provision. The current draft expands the notice to cover property owners within 300 feet of the proposed location. 300 feet was selected because it matches the requirements under zoning law. And we explain in the regulation the effect of doing that. I think it does enhance public notice, but the town will still adhere to statutory requirements that apply. Also, in response to a comment from CTIA, the town clarified the definition of personal wireless service provider. We make it clearer that that definition applies to all carrier neutral entities, not just distributed antenna systems, so long as those entities meet the eligibility requirements. Also, in response to CTIA, the time frame for completion of the facilities has been extended from 6 months to 12 months. The reasons for the change are described in the town manager's memo. Next, we retain the peer review provision. I'm going to backtrack for a second and just provide some references to the sections I've been talking about. The notice of hearing provision is in section 35L. It's on page 13 of the revised draft. Personal wireless service provider definition, again, section 30, part 5, part A on page 7. Timeframe for completion, section 30-6 C1, page 29. The peer review section, which is unchanged, is 30-5H on page 10. Next, there were a number of comments on technical feasibility in aesthetics. We believe that the regulations properly reflect the FCC standards. Under those standards, reasonable means that aesthetic requirements are technically feasible and reasonably directed to avoiding or remedying the intangible public harm of unsightly or out of character deployments. We believe that the regulations comply with that. The section on undergrounding has been modified in order to track the FCC's September 2018 order. It covers undergrounding as that relates to locations which have been formally designated as underground areas pursuant to Chapter 166 of the general laws. That's under section 36B5, page 17. In response to another CTIA comment, we clarified requirements regarding unmetered electric service in part 30, section 6B6, page 18. What that's intended to do is require unmetered electric service if that unmetered electric service is a tariff offering of the electric company. It's not requiring an applicant to negotiate with the electric utility or to obtain special permission from the Department of Public Utilities. So it's, I don't believe that Eversource has such a provision in its tariff, so I don't see it as a current issue. There are a number of comments on radio frequency emission provisions. We did not change the ones that were there. We did make an addition to add a requirement that an applicant provide its RFE safety practices and share that information with the town. That's in part 30, section 6B7, pages 18 to 19. We retained limitations on the deployment of new poles. It is important to note that an exception can apply if alternative locations are unavailable. For example, the pole owner refuses to make that pole available, or it would be technically infeasible from a service standpoint. In the performance bond was reduced to $10,000 to better track the anticipated cost of removal of wireless facilities. This provision, we'll revisit it based on experience if it comes up. One concern is the cost of disposal and whether that's going to be covered as well, in addition to the cost of removal. That's section 36C6 at page 30. We made some modifications to the fire and safety specifications, and frankly, it would be helpful to get more information from the pole owners and the wireless industry on this, so that we have something that accurately reflects some of the practices. Also, ART raised this issue, but more information on this would be helpful. That's part 30B, 19U, page 27. The town manager added a minimum spacing standard of 300 feet between grantee locations. And the reasons for adding that are explained, both from a safety standpoint, avoiding incommoding public use of the public ways. And it doesn't prevent the applicant from seeking shorter spacing. We did receive comments objecting to this provision, but we believe that it's consistent with the FCC's September 2018 order. In that order, the FCC recognized that some spacing requirements may be reasonable aesthetic requirements. We think these are. Moreover, the requirement doesn't prevent the replacement of existing facilities, and even under state law, some replacements might not require town approval. Co-location of new equipment on an existing pole would not be affected. The insurance policies requirement was modified to require the provision of the actual policies. It is necessary to see the fine print. That's part 30, 6C 8, page 31. Also, the town manager added a requirement that grantees provide annually a list of locations that are in use and those which are not in use. That's section 36C, so part 2, page 29. Finally, if a grant of location is revoked under the regulations, it would be necessary for a grantee to reapply for a grant of location. And that's under section 36C, page 29. That's a sampling of what the changes consist of. There are more that are, again, referred to in the memorandum and in the red line regulations, and we hope that's helpful.
Thank you very much for that summary. At this point, since it is a public hearing, we'll open the public hearing. We have our Director of Communication, Lynn Poyant, here. Lynn, do you want to facilitate the public comment period?
Thank you, Mr. Clyburn. As is customary, we will ask our elected town officials if whether or not they have any comments. So Councillor Atzlis, would you have anything that you'd like to say?
Just briefly, thank you for everyone getting together here, and I appreciate all the time and effort that all parties involved had put in, both from town manager's office, town attorney, Mr. Mandel, of course, the residents who have been patiently awaiting these regulations and had a great deal of input and were excellent to work with. We often say we wish that more residents operated in that fashion in order to help us get things done on their behalf. And I want to just offer kudos to the residents of Centerville in that particular neighborhood in precinct 4. I just want to thank everybody. Some of them are on the call, some of them are not, but I just wanted to acknowledge everybody that had a hand in this. So thank you.
Thank you, Councillor Atzlis. First up for public comment will be Jennifer Lynch. Jennifer, you may turn on your camera and unmute.
Thank you, Lynn. I just had a few comments, a few informal comments. If the street noise in the background, you can hear it. I'll shut the door. It suddenly seems really loud to me. Can you guys hear it? Okay, maybe not.
You're loud and clear.
That's
Okay.
fine.
Okay, super. I just have a few comments, specific and general, and I'll try to be brief. I will be brief. I'll try to run through them quickly. First and foremost, I also would like to thank the town. I'd like to thank Mark Ells, his legal team, his planning team. And so I'd like to sincerely thank all of them for their hard work and commitment to this, and for the learning curve and the need to stay on top of this ever-changing and very important issue. I'd also like to thank Nick Atzlis for staying on this with us, supporting us and advocating for us to the town and being a liaison for us. And he really stuck with us and went to bat for us when it seems like things were quiet and weren't moving forward. And we deeply appreciate that. I'd also like to thank Doug Wood, the director of Americans for Responsible Technology, who's not here today, but he has been on several calls, and He guided us throughout the past few years, and without him, I don't know where we would be. And finally, I'd like to thank Janet Davis, who wasn't able to be here today. She's the head of the Centerville Concerned Citizens. Janet started this whole thing. So I deeply thank everybody I mentioned and anybody I may have forgotten to. So I also wanted to ask you to please keep going on this. In fact, I wanted to propose the creation of a committee to review this document, this ordinance, every 6 months. And I know committee is kind of like, oh, the last thing we need is another committee. And we can review this anytime. We don't need a committee to do it. But the way things go, things get on the back burner, other things take priority. And I'm wondering if actually creating a committee to actually be required to sit down every 6 months and look at this and propose updates and changes might be a really good idea, because this is such a fluid issue. This is such a fluid document. Things are changing literally daily. And we need to keep up to date with changes in with what other towns are doing. As you know, I'm sure you've seen communities all across the country are taking strong stands on this. They're passing bylaws and ordinances, some of which are very bold and strong. And I know we're all waiting to see if they will be upheld, and if they will in fact be upheld. And so as they are upheld, and as laws change and as regulations change, we want to be in a position to continue to make this ordinance as strong as it possibly can be. And so I think creating a committee of citizens and town officials to review it, let's say every 6 months, and propose changes might be a really good idea. I also wanted to encourage you to, after this is done, move on to freestanding towers on private property and on public property, because as you know, the small cells is just one piece of it. So, okay, I'm moving on. I wanted to suggest, instead of a 100-foot setback, a 300-foot setback from residences. Some towns are doing this, and I think that would be stronger. I have here what towns are doing it. I think Fishkill, New York is doing it, and White Plains, New York just passed an ordinance with a 250-foot setback. And I also don't know why, I guess I do know why, because the memo mentions clutter, why existing poles, are grandfathered and not subject to the 100-foot setback. To me, it seems like it makes this particular provision ineffective to only apply to new poles, because most communities, the poles are there. And I do think clutter is preferable to cancer and exposure to radiation. So if it's not too late, and I guess it's not, since we're holding a public hearing, I'd hope you would consider a 300-foot setback instead of 100-foot, and see about the grandfathering or not grandfathering of existing poles. And the idea is let's get these things as far away from people in bedrooms and children and homes as possible. Liability insurance without a pollution exclusion, I think that's really, really important. And I was doing a little reading, and I came across something on something called law.com, and it was talking about PFAS chemicals, but it said with respect to the very same situation, identical analogy more or less, but it was with PFAS, not radiation, but it said that courts have, this is a quote, courts have long held that the pollution exclusion is inapplicable for product liability claims. So I don't, I don't pretend to be an expert on insurance or anything else, but to allow the telecoms and the insurance companies to say, well, the insurance companies don't provide this insurance. What are we going to do? Well, insist on it and say, well, either get the liability insurance without the pollution exclusion, or you don't do business in the town of Barnstable. And then the response would be, well, then you're denying coverage to your residents, and you're preventing us from doing business here. Well, my analogy to that is, if somebody wants to sell Skittles on the street corner, And not only that, they want you to give them the street corner. And you say, well, you can't sell Skittles on the street corner here. You say, well, then the town of Barnstable won't have any food. Well, look, we have plenty of good coverage. So we don't need super duper coverage. We have coverage. It's just like saying, if I can't sell Skittles, then the town of Barnstable is going to go hungry. Well, no, we're not. Okay. So the pollution exclusion, without the pollution exclusion, I think that's really important. And the fact that the telecoms don't want that, I do think speaks volume and is an admission that their product is dangerous and they know they'll be sued. Okay. I do think the stealth and the strand mounted language should be stronger. I also just want to point out that the telecoms have successfully convinced communities and the public that our hands are tied. And that's an expression you hear all the time. Our hands are tied, our hands are tied. And I don't know if any of you happen to see a particular podcast or presentation where one of the very active attorneys in the country who works with communities on this very thing is Scott McCullough in Texas. And he's got a little plaque on his desk. And if you can zoom in, if you ever happen to have the opportunity to see him again, his plaque says, only one finger tied. And the point, of course, is our hands are not as tied as we think they are. We have one finger tied. And so I encourage you to continue to do as much as possible. And I do believe this particular issue is more fluid than even a lot of issues that are fluid and ever changing, because it's just changing so quickly. And combined with that, it's also so very dangerous. And I don't think we should continue to accommodate this very, very hazardous industry. Which brings me to my point of fiber optics. I want to encourage the town to look into fiber optics as a way of providing internet and telecommunications to the community. It doesn't involve radiation. It's cheaper. It's, from what I understand, it's cheaper. It's safer. It's better. It's more effective. And it would not require us to continue to accommodate a very hazardous technology, a lucrative technology, yes, for the telecoms, but a very hazardous technology. I was wondering why on page 17, section D was removed regarding facilities being 300 feet apart. I know that Attorney Mandel just addressed that. I didn't quite get it, but anyway, I just wanted to throw that out there. I've mentioned White Plains, which just passed it looks like a good ordinance. And let's see, I guess that's it. I did want to, if I could, I did want to read one brief comment from Janet Davis, who wasn't able to be here today. Would that be okay to read that?
Yes.
Okay. Janet says, I was going to thank the town and ask that they stay vigilant for any applications that would involve EMF exposure to families near their homes, much like the tower on Main Street in Centerville. The Centerville Concerned Citizens will continue our quest for safer internet options, fiber optics being the most cost-effective and responsible bridge for internet access for everyone in our community. It's faster and keeps our data more secure from hacking. That's the end of Janet's comment. And I think that's all I had to say. Thank you very much.
Thank you so much for all your comments, for your work on this, and for passing along Janet's comments as well. We truly appreciate it.
Sure thing.
Thank you, Jennifer.
Thank you. Next up is Jeremy Crandall. Jeremy, you may unmute.
Yes, thank you. Can you hear me okay? Great. Mr. Clyburn, other town staff and legal counsel, my name is Jeremy Crandall. I am back before you again today to testify on behalf of CTIA. We represent the wireless industry. We're the Wireless Industry Trade Association with comments and concerns related to the most recent draft. First of all, I very much want to emphasize that CTIA and our members continue to appreciate the opportunity to engage with you all, with the town on these regulations. We are very thankful for the revisions that were made, that the council walked through, that were based on our previous letter in March. And very much want to emphasize that we continue to be strongly committed to improving connectivity for residents and businesses in the town. And we do feel that a number of changes that were made will help us make progress to ensure that there's no community that's left behind when it comes to accessing wireless services. There are still a number of other proposed regulations that we believe continue to impose substantially burdensome requirements and very well may violate federal law. The letter that CTIA submitted on the most recent draft goes into detail on 3 such provisions. I'm going to briefly summarize them here because the letter obviously speaks in more detail. First, we do have serious concerns about the 300-foot separation requirement for personal wireless facilities. I did hear the feedback from the legal counsel on that. I just want to emphasize that expanding wireless service into the future as technology evolves does increasingly rely on the use of small cell technology. Small cells are far less obtrusive than macro towers, but they also very much depend on both location density and the unique geography of an individual area to ensure sufficient coverage. And so imposing that arbitrary distance limit with not much detail in terms of clear reasoning or modification criteria, we believe will have the effect of prohibiting service. I do want to also just flag for you all, and we put this in our letter, to caution you all in taking this action at this time, considering there is a federal court that right now recently invalidated a similar requirement in the city of Pasadena, Texas, that a provider's small cells be separated by at least 300 feet. And I do also believe that ruling was appealed by the city. Second, we continue to find serious legal and practical challenges with the requirements that are in a number of sections that require an applicant to demonstrate there's no feasible alternative to a facility location. I want to provide a little bit more background on this element because I very much understand where you all are coming from in this regard. But by way of background, our providers must already conduct extensive technical studies to determine how we can best achieve reliable service coverage while also minimizing the number of sites that we would build to accomplish that goal. And that second part is so critical because that's at its core about ensuring a positive ongoing relationship between your community or any community and our members. And so we do stand by our position that compelling a provider to prove in a number of ways there's no other feasible location intrudes on the provider's right to design its network in accordance with FCC rules. I want to emphasize that. And it's also important to keep in mind, looking through the totality of the ordinance, or the regulation, that there's already a host of mechanisms in place to ensure the size and shape of our wireless infrastructure is appropriate for your community. And so, as you know, there's a number of other provisions that address antenna height, surface area, color, lighting, fire safety, and other safety concerns. And so we believe those aesthetic standards are sufficient to protect the town's interest. And so would insist on deleting those feasible alternative elements. And then finally, we must renew our objection to the sections that we believe unlawfully impose requirements related to radio frequency emissions. Put simply, in this space, the FCC has the exclusive authority to determine substantive compliance with RF exposure guidelines. While providing proof of that compliance is one thing, and it's absolutely something that we can do, the proposed amendments do impose a level of ongoing monitoring and reporting obligations that go far beyond what the FCC rules require. And so we would press for removal of those sections. So in closing, I very much sincerely appreciate the town's willingness to continue a dialogue and listen to our feedback with these various revisions. And for addressing our concerns. And really our advocacy for these remaining provisions that we address in our letter is really all about so we can continue to make progress on connectivity for the town of Barnstable. So I'll stop there and thank you for your time.
Thank you very much for your comments and for the written letter as well. Much appreciated. Lynn?
Thank you. Next is Anissa Reed. Anissa, you may turn on your camera and unmute.
Oh, apologies. I'm just listening in today.
Thank you. Next would be Barry Cosgrove. Mr. Cosgrove, you may turn on your camera and unmute.
I'm just in listening mode today, but thank you very much nonetheless.
Thank you. That concludes our public comment for this item. Thank you.
Excellent. Well, thank you all for coming in, providing comment. It's much appreciated. With that, Karen, am I free to close the public hearing? We will be, as Karen mentioned previously, we will accept any comments through the 28th of July. So if there are any comments that folks have, please submit them to Elizabeth Jenkins. That information has been part of the posting to date. Karen, did you have anything further?
No, I think that's it. Just that the comment period will remain open through the 28th. And then we will try to issue final regulations as soon after that as possible.
Excellent. Do we have any other questions? Comments? All right. Again, thank you all for your participation. I know this has been a long road, but we truly appreciate everyone, particularly our citizens that have been so involved in this process. So we'll look forward to wrapping this up on the 28th of July and moving forward as expeditiously as possible. Thank you.